They made technical mistakes in the bill, again because of the bad faith in which they were operating yesterday. Now, by using the word for avoidance of doubt, actually their intention should have been, I believe it was, to use the word notwithstanding. That notwithstanding would have subordinated the exemption clause to the application clause. But they forgot that. They did not forget it, probably they didn't know. So ours was to let them trap themselves, because the English say, when your enemy is making mistakes, you do not interfere.
The impugned past bill now is inactive, but it is pending presidential assentment. The same is tainted with a number of weaknesses. For instance, it is unconstitutional. It is against known international principles regarding human rights, good governance, rule of law, and constitutionalism. The same is tainted with the abuse of the doctrine of separation of powers. You remember General Museveni recently communicated to the effect that he called the chairpersons of the two committees which were handling the bill and guided them, ordered them, directed them on what to do. That is against the doctrine of separation of powers. The same bill was suffering several weaknesses, gaps, including but not limited to vagueness, ambiguity, among others. It had to be withdrawn. They had to frame a new one for consideration by court. I don't think it will survive. We are going to peruse and scrutinize. We are likely to sue the Attorney General in respect of that impugned law.
Amen. Ideally, before a law is proposed, there should be a very comprehensive regulatory impact assessment done so that we're able to understand how the law will over time contribute to our socio-economic development. For example, yesterday things like economic sabotage were outlawed. Promoting foreign interest was outlawed. So from where some of us sit, it would have been very important that the country gets to know what amounts to such promotion. Because, for example, if, as we see here, some of the people are dependent on always getting treatment abroad, would they be promoting foreign interest? If the agencies for, say, very productive and commercial purposes, and it seeks to promote foreign products, would that be working against Uganda's interests? So small things like that needed to be clearly understood. What would amount to an economic sabotage? You see, all such should have been clarified properly so that Ugandans know how this law will impact them. And fears that the law was touching on violation of certain non-derogable rights. For example, if a proposal is made that the minister can be able to act without maybe a due process, say maybe revoke certain licenses, maybe act without giving opportunity to someone to maybe respond, will that be fair hearing? You are aware Article 44 lists some of those non-derogable rights, and the right to fair hearing is one of them. So things like that needed to have been corrected so that the law is not perceived as intended to target a group of people, but it is for our posterity. And I think that is what everybody sought to achieve. It didn't matter if you were on the side of government, it didn't matter if you were on the opposition side, the law will affect you.
Final Honorable, let's look at
The presiding officer, according to some members, did not allow the same opportunities accorded to other people, to every member. For example, you saw Dur say he could not present in 5 minutes, and yet the rules entitled him to the same minutes which were accorded to the other members. So in terms of balancing, you know, there was no elaborate debate. We should have discussed the objectives and the principles of the bill before even going to the third stage. That did not happen. And there are people who had actual matters of procedure to raise. For example, an assertion was made by one of the MPs, Honorable Segona, that the law violates Article 44. And our rules, Rule 133, is very clear that Parliament shall have no power to bring bills or motions or amendments on anything that, you know, derogates those protected rights. So things like that, we needed rulings on them so that we know the law was indeed intended for the country, but not to advance any group of people against the other. Because we are Ugandans, what must serve I as an individual must serve you. And that is the spirit we would want to see in the 11th Parliament. Above all, I mean, in the 12th Parliament, above all, I insist going forward, all proposed bills must have regulatory impact assessment so that we do not get into the kind of scenarios that have happened in the past. I thank you.
People of Uganda, we have put in place a law that seeks to protect our sovereignty as a country. Now, in protecting our sovereignty as a country, we are also following other countries that have put in place such legislation to protect their own sovereignty. There are countries, for instance, Canada, their law on their sovereignty is called Countering Foreign Interference Act of 2024. The United States of America has the Foreign Agents Registration Act of 1938, the oldest under sovereignty. Singapore has the Foreign Interference into bracket Countermeasures Act of 2021. South Africa has the Protection of Investment Act of 2015. Kenya, when you read their Treaty Making and Ratification Act of 2015, is also about protecting the national interest and the sovereignty of Kenya. So we are not inventing the wheel. This is the way to go. The people of Uganda must be alive to our history as enshrined in our national constitution, the preamble. We, the people of Uganda, recalling our history characterized by political instability, and who were the actors bringing political instability into our country? Majority are foreigners. You remember in the Singapore CHOGM meeting, where the then president of Uganda, Paul Milton Obote, was chosen by African leaders to represent them. I'm told he roared like a lion. But the then Prime Minister of UK gave him assurance that there are people speaking here, but you may return to your countries and you may not find your legitimate governments in place. Now, it is also alleged that there are 2 countries that used their agents that were at that time in Uganda for purposes of bringing down the government of Obote. They supported Amin in the coup. Is that the trajectory Ugandans would want their country to take from the current peace we are enjoying? You have seen countries falling. They are not falling on their own. They are falling because of external influence and interference. And that is what the law seeks, to protect the people of Uganda against.
Does this seek to isolate Uganda from the rest of the world?
We are not isolating Uganda from the rest of the world. That is why this particular bill is not in any way affecting direct foreign investment. This bill, as passed, is not affecting donations to our religious denominations. This bill is not affecting remittances from Ugandans abroad. This bill is primarily on protecting our sovereignty against foreign and external influence and interference.
And lastly from me, some of the opponents say they are going to court because there are a lot of procedures which they think they are not right, as how the bill was hurried passed.
Definitely, that is the beauty of the democratic processes of Uganda, that whoever feels aggrieved has the right to take that route. But we also feel that we complied with the rules of procedure of Parliament. We complied with the Constitution of the Republic of Uganda. If there are Ugandans who are discontented and they would wish to exercise their constitutional right of going to court, there is nothing I can say. I believe the chambers of the Attorney General, as the principal legal advisor, would be ready to defend the position taken by government of the Republic of Uganda that has a social contract with the people of Uganda in court.